Can you be placed on child support without being on the birth certificate? Yes, and it's been happening since the 1970s. Here's how. In 1975, Congress created Title IV-D of the Social Security Act. It required every state to establish a child support enforcement agency. The goal? To recover welfare costs by going after the non-custodial parent. Once that law passed, the focus shifted from protecting families to reimbursing the government. So how do they decide who to go after? They don't need the birth certificate. They only need someone to name a possible father. And if the alleged father doesn't show up to court, he can be ruled the legal father by default. No DNA, no evidence, no due process. Once default paternity is established, child support enforcement begins. And undoing a default judgment? That's another legal battle entirely. So how do you fight it? First, show up. If you were never properly served or didn't know about the case, you can file a motion to vacate the judgment. That's called a motion to set aside default. You'll have to explain why you missed court and provide proof you're not the biological father. Most states only give you a short window, sometimes 30 or 60 days, from the date you found out. Miss that window and you could be stuck. Second, request a DNA test before paternity is established. That right usually disappears once a court order or acknowledgement is signed. Third, don't sign anything unless you fully understand it. A voluntary acknowledgement of paternity is a legally binding admission. Hospitals push it, agencies encourage it. But once it's signed, it has the same legal weight as a court ruling. And if support is already being collected, even DNA proof might not be enough to stop it. Because the system isn't built on truth. It's built on liability, and liability pays the state back.